5 seconds to go. Start. This appeal is directed against the judgment and order dated 29th February 2016 as passed by the High Court of Delhi at New Delhi in Criminal Appeal number 879 of 2013, whereby the High Court has dismissed the appeal against the judgment of conviction and order of sentence respectively dated 3rd September 2011 and 8 September 2011 as passed by the Court of Additional Sessions Judge for Rohini Outer Delhi in Sessions Case number 238 of 2009, whereby the appellant was held guilty of offences punishable under sections 302 and 201 of the Indian Penal Code 1860 and was awarded varying punishments including that of imprisonment for life for the offence under section 302 IPC. Before dealing with the matter in necessary details, we may draw a brief outline to indicate the contours of the forthcoming discussion. The allegations against the appellant had been that on 3rd May 2009, he took his two sons, aged about 9 years and 6 years, to Haidarpur Canal, strangulated them, and threw the dead bodies into the canal, and thereafter attempted to project as if it were a case of accidental drowning. It was also alleged that the appellant was a drunkard who doubted the chastity of his wife and suspected that the children were not his sons. In that, two of the prosecution witnesses, PW5 Bishan Singh, brother of the appellant, and PW9 Sunita Yadav, wife of the appellant, did not support the prosecution case as regards conduct and behavior of the appellant. However, the trial court held that all the essential and material facts were duly established in the evidence adduced by the prosecution, including that the deceased children were last seen in the company of the appellant, who took them to canal and later on informed the staff at the Haidarpur water plant and at the petrol pump, as also to the police, that they accidentally fell into the canal, that the cause of death of both the children had been asphyxia as a result of manual strangulation, and that the appellant was a drunkard who doubted the chastity of his wife and thought that he was not the father of the deceased children. The trial court therefore convicted the appellant of the offences under sections 302 and 201 IPC and awarded the punishments accordingly. In appeal, it was essentially contended on behalf of the appellant that there were missing links in the chain of events, particularly when the allegations of the appellant doubting the chastity of his wife were not proved, and hence there was no reason for which the appellant would have killed his own sons. Per contra, it was submitted on behalf of the respondent state that the children were lastly seen in the company of the appellant, and it was clearly established that they died due to manual strangulation and not on account of drowning, as falsely suggested by the appellant, who otherwise failed to discharge the burden in terms of section 106 of Indian Evidence Act 1872 of explaining the circumstances leading to the death of the children by strangulation. The High Court again minutely analyzed the evidence on record, and while rejecting the contentions urged on behalf of the appellant, dismissed the appeal and affirmed the findings and conclusions of the trial court. In challenge to the concurrent findings leading to conviction and sentencing of the appellant, it has essentially been contended on his behalf that when the story of strained relationship between the appellant and his wife has not been supported by the material witnesses, including the wife of the appellant, there was no reason or motive for the appellant to kill his own sons, and the alleged want of explanation on the part of the accused appellant cannot be a ground for conviction in the present case. It has also been contended that there had been a fundamental defect in the trial when the trial court omitted to examine the capacity of the appellant in terms of Section 329 of the Code of Criminal Procedure 1973, while ignoring the material evidence on record to the effect that the evidence was not a person of sound mental disposition, for he was admitted to a rehabilitation center for de-addiction and was discharged against the advice of the center. The facts regarding treatment of the appellant for mental illness post conviction have also been referred to in this regard. On the other hand, it has been contended on behalf of the respondent state that when the deceased were lastly seen in the company of the appellant, the burden was heavy upon him to explain the cause of their unnatural death, which he had failed to discharge. Rather, he gave false information about accidental drowning of the children. It has also been submitted that the plea of unsoundness of mind as taken before this court remains untenable for the same, having not been raised in trial or even in appeal before the High Court. Stop.